Hello, good evening. Hello. From California. Well, hello. Oh, lots going on over in the California. I am still getting my situation set up here, but welcome in. I'm hoping that by coming on a few minutes early, the notifications will show for everybody, but we just never know. It's always a little bit of a surprise. Like, did they get it now? No. So keep working on it. Hello, Alan. Hello, Tia. Hello. Welcome. Cecilia, welcome in. Let me, I'm gonna pull this cord. Sorry, everybody, hold on. There we go. Wow. That was crazy. All right, now I've got to move my computer a little bit closer here. I try to keep it out of frame as best as I can, but yeah, that's a fail. Usually that's a fail. Hello, Sally Doc. Hello. I'm in California right now, despite everything. Oh, I know. Oh my goodness, yeah. Yep, I'm jealous. Alas, I am in a big, giant red state in the middle. So not a lot going on here. And sometimes that's okay, but sometimes it'd be nice if something was going on here as far as activities or people. That would be nice. Yes, happy to be back, Cecilia. Yes. Hello, Soul Rose. We had started over on the TikTok. Oh, that'd be great. Yeah, let them know. I have put a little bubble up over there at the TikTok, but I'm only going to read the California case over here on the tube. So we had started on Tuesday, and we got to kind of keep it going. So I did start the Alien Enemy Act case. So that's the WMM case. I did start that this morning on TikTok, but I really want to keep the California case over here because then I don't have to be so careful about trigger words like law. So I appreciate that. Hello, Bruce Wayne's mother. Hello, Doughboy. Nope, I'm coming in. I'm a little early myself. I'm hoping that if I came on a bit early, we would get more people with notifications. All right. Now, hopefully that's okay. Am I close enough to the document, everybody? I want to ask that. On the northeast coast. Oh, wow. Okay. Nice. Anything with the coast, I'm, jealous. People on TikTok. Thanks, Doughboy. Appreciate that. Hello, Tia. Welcome. Made my tea with Manuka. Oh, nice. That's a great way to pamper yourself or just, have honey. So Doc looks good. Thank you so much. I appreciate that. Usually I'll be able to tell if it's too high or too low, but it takes a little bit to get her started over here. Now, tomorrow's Friday, right? Right? That's not just wishful thinking. That is actually what tomorrow is. Egads, this has been a long week. This may be one of the longest weeks this year, and that's saying something. Because we've had a lot of long weeks, but this one may be leading the pack here. All right, so Gavin Newsom. I want to make sure I've got my sticky note up here. Mr. T. Rump. That's the other thing too, is I can say his name over here. So that's kind of nice. Now we do know the new community guidelines are coming into play pretty soon. I think maybe in a week over on the talk. So we're not really sure exactly what things are going to look like after that. But I will be here for sure. And I will be hopefully over there. I'm not sure if I will get booted out or not, but we'll just kind of have to wait and see. I hope I don't get booted, but you know, if it happens, it happens. Oh, thank you. Oh, look at that. Oh, I appreciate you so much, James. James 619. I do. Oh, I just saw you made a comment over on the TikTok today, and I was like, hey, wait, is that a new name? And it was no, it was you, and I was like, thank goodness. Oh, it was good to see you for sure. Yes, yes. Good evening. Good evening. Welcome, welcome in. Welcome in, everybody. So one of the things that I think is so nice over here on the tube versus the talk is that we can actually, like, I can actually see full sentences as they're coming by. So I can catch questions, and I do appreciate that. Sometimes on the talk, it's hard to get the questions because they're going too fast, or, you know, they're not very appropriate. So it's nice to have a nice big screen over here, and I appreciate that. Right, right. So we've had several big cases come through this week and last week as well. We had, of course, the big Alien Enemies Act case that the opinion is out now. Came out on September 2nd, same date as this one. And that's probably the most important case. And I hesitate to say one case is more important than another because they're all important. They all work together, right, to finish the puzzle. But this one's like a really big piece. This would be like an edge corner piece. If you puzzle, you know what I mean. So the Alien Enemies Act is pretty huge as far as legal goes. The next one that could be tied actually with the Alien Enemies Act is this California case, because there is such a huge question of state versus federal power in this case involving the National Guard and also, you know, our militia, the militia that we don't call them militia anymore, but essentially the militia is the National Guard. So that's important. Characters in our comments as well. Yes, I agree, Willie B. I agree. It is quite nice. I do appreciate that too. So between the two cases, I don't know that I could pick one that's really more important. The other one's just longer, but I really do want to make it through this Newsom case because, again, it's setting out precedent for how the federal system and the state systems are supposed to work together. The National Guard coming from Chicago. So, yeah, I'm not sure what exactly is going to happen. I will say that Illinois has already sued the administration in late June, I believe. They filed a lawsuit claiming that they were having some negative retribution because of the sanctuary city standing. And so that lawsuit's already been filed. But we also have several things that have been filed by the mayor in Chicago. The mayor has filed an executive order. So we've got that going. There's Chicago's like ready to fight, and I'm living for that. I think that's great. I think that's fabulous. You know, if everybody there was like, yeah, whatever, we're happy, this is great, you know, so be it. But they're not. They're not happy there. So you gotta kind of take that into executive order to really defense. Interesting. Well, VC, that was its original name. And originally, I don't think it was defense. I think it was, well, let me see, was it Department of War or was it War Secretary? Well, anyway, either way, we're getting kind of combative, I think, with this situation. So the names of the people on the cabinet are set out in the law itself, even though we don't have like great descriptions. So my guess, and this is just my guess, I reserve the right to be wrong, but I would think it's Congress that actually names the pieces. Now, the, of course, getting them onto the panel, what the panel does or cabinet does, that's up to the executive branch. But I think the skeleton outline of how many heads of different departments and what they're called, I think is Congress, but we shall see. The other thing too is that we had the worm guy, what's his name? Excuse me, Robert Kennedy Jr. He was, I guess, talking in Congress today. I've not seen it because I'm not ready. I'm not ready yet, so I'm gonna have to set a time. Maybe we should do a live on that. That would be interesting. We might be able to do that and be like, what are we watching? Okay, so we can all have some support through the process. So we may need to do that. We'll have to see. We'll have to see. But yeah, that was also going on. So we have these cases. We had the Harvard case came down. We had the alligator Alcatraz case that came down. We've had a little bit with Abrego Garcia, only in that he has been taken into custody. And so we've had quite a bit going on this week. Getting cooked. We love that. We love that. I mean, if you want to take here's the problem. If you are that unqualified, you should not be in a cabinet position. And it's offensive because it seems like they're not even taking it seriously. They're just looking for loyalty. And as we all know, loyalty does not mean that you have the competence to go forward. So that's that. That's how that went. Yeah, it's hard to listen to him talk. Yeah, he's got some kind of a vocal thing, right? Where he's I mean, some people have it. The is it the Solicitor General fella? Sauer, I think. There's two attorneys for Trump that were working with him, and there's one that's the attorney. Oh my gosh, there's one that's arguing from the Supreme Court, so the solicitor, and then the other one is the second in command of the Department of Justice. Okay, Sauer. Okay, thank you. Okay, so yeah, he's got a real rumbly voice too. And I remember listening to arguments and his side, and I was just like, what? And I've got no room to speak at all because I get a bit rumbly myself, but that's like real rumbly. I'm just, ugh. Anyway, that's gotta be rough. Yes. One of the G's. It's just one of the G's. Pick your G, everybody. All right, so we have tipped over the 7 o'clock, so I will go ahead and start diving in here with my sticky note. So this is the case again where the judges here have set out whether or not it's okay for the federal or the executive, so the president, to pull in, and Hegseth and the DOD people, to pull National Guard in and order them to California without the agreement or any of the elements needed in order to actually do that. They're just saying well, we don't think you are being lawful, so we're going to send our own people over there. Now, the problem, of course, is that we have a law, well, we have several, but the one in particular that we talk about in this case is Posse Comitatus. And Posse Comitatus itself translates into the phrase local law enforcement. All right, so the thing about Posse Comitatus, it's only a couple sentences, and it's basically saying that the military may not participate in local law enforcement. That's the actual name of the Posse Comitatus, is local law enforcement. War Department until 1945. Okay, yeah. I'm wondering why they changed it. I mean, maybe, during the decade of prosperity that we had. Oh, wait, we didn't. They must have changed it at some point. So I blame the libs. I'm just kidding. Still too soon, though. Too soon for that joke. Oh, my goodness. The mood ring. Yes. Oh my God, that's a lot of fun. I think my mood ring is very fun. So we got to have a little bit of fun when we're looking at this. Last we met on Tuesday, everyone, which is under my live tabs if you're looking for it. So part one, we did make it through quite a bit here. And although this says 52 pages, it's actually, I think we've got back here, this is the docket actually. So this is the Everglades docket. Let's move that out of the way. That way it won't look so overwhelming here because we don't need that. Oh, I thought he skipped around a little bit more, but no, I was wrong. So it is 52 pages. Jesus, take the wheel, please. Yes, just started. I'm just up here babbling, Jen. Hello from Russia. Russia's coming. Well, I don't know why. I don't think they'd want to be over here. Our rules, we have different rules over here, so I don't know about that. All right, and then we went through here. These are some of the slides, and to remember also, everybody, there was a full evidentiary like trial, I guess, or evidentiary, we'll call it a trial. There's no jury, but they presented evidence and they presented exhibits, both sides, to follow up with what they're talking about here. So a lot of our citations are actually exactly in the trial transcript where somebody said something. And so I think that's very important as well. So every little piece here is backed up, and you can see that pretty much every sentence has a footnote or a citation, and that's because they're saying, like, we're not just, saying it for funsies. This is what the actual evidence is showing here. Oh my gosh, the disco ball. Oh, I love it. Oh, thank you so much, Kristen. Oh, I appreciate you. So that's where we were here. All right, so we're kind of going through, looking at what the judge pulled out of the trial transcripts, looking at the different pieces of evidence, and that took us to the second heading here, which is operations outside Los Angeles County. So this is where we left off last time. Oh, you're so sweet. Oh, Kristen. Oh, it's been tough seeing you lately. I hope you've been able to move into a shift that works out okay for you, because I've missed you. Like, I know you're out there, but I haven't seen you. It's been rough. So yes, right. Away from the aggressive connotation, and thought defense was better. All right, well, sure, whichever. So I will go ahead and get started in here, everyone. We're going into part two, which is on page 13 for those following along at home, and I will just leave the moderators to do what you do, and I will just dive in here and start reading. Love the graveyard. Oh yeah. No heat, no people. Oh, it's a good point. All right, number 2, operations outside Los Angeles County. Task Force 51's assistance, right? So we had talked last time that this was a special task force created just for this kind of a situation, right? So Task Force 51's assistance to federal law enforcement operations in Southern California expanded beyond Los Angeles. The evidence at trial showed that federal troops were deployed 3 times in support of federal law enforcement operations targeting marijuana farms, one in Mecca or Riverside County, once in Carpinteria, Santa Barbara County, and once in I almost said Caramello, Camarillo, Ventura County. I wish it was Camarillo. All right. And next is Mecca. So on June 18th, over 300 Task Force 51 troops were deployed to support a DEA operation with only about 200 federal law enforcement agents at a marijuana farm in Mecca, California, over 140 miles from downtown Los Angeles. So they're showing, like, this isn't just about crime in Los Angeles, right? Because that's what they're saying. We have the right to pull in National Guard because local law isn't being followed, and it's not being controlled by local law enforcement. So what they're saying is, well, what about Mecca, which isn't anywhere near Los Angeles? The troops were stationed several hundred yards outside the farm itself, where they established a security perimeter with riot shields and military vehicles. The underlying DEA operation targeted illegal narcotics activity, and the operation resulted in the seizures of narcotics, approximately 87 suspected human trafficking victims, and disruption of illegal marijuana cultivation tied to organized criminal activity. Right, and then that's again being pulled out of a trial exhibit here, so Exhibit 41. Carpinteria on July 10th, between 100 and 120 Task Force 51 troops were deployed to a cannabis farm in Carpinteria, California, over 80 miles from downtown Los Angeles. There was no specific threat or risk of riot in Carpinteria, and DHS notified California Highway Patrol and the Santa Barbara County Sheriff's Office only at the time of operation. So they already knew what was going on. So that's a good question too. That's a quick side note, that they were intentionally going into the marijuana fields. I mean, I think that's, they're like, well, hey, maybe they don't appreciate that. And so they're going into those kinds of fields as opposed to the fruit fields and stuff. Okay. Now, we don't have legalized marijuana in my state, except for extreme medical situations. So we don't have any of this. So I don't know exactly what this must be like, but it seems to me that they're prioritizing different kinds of crops. Right, coordinate locally when they want to. Yep. All right, so Homeland Security investigations requested Task Force 51 to help set traffic control points. Keep in mind there's a list of things you may not use according to Posse Comitatus with the military, and traffic control is one of them. Because without the troops, federal law enforcement agencies would have had to station more personnel at traffic control points, which would have slowed down the operation. So again, everything's being done as quickly as possible. And when you do things so quickly, of course, you violate different rules and laws. That's why the legal system's so slow, because we try to make sure we follow all the rules. The risk of inaction was low given the volume of HSI personnel on the scene. Task Force 51 troops and federal law enforcement officers together blocked traffic on Casitas Pass Road on the outskirts of Carpinteria. David's Carpinteria photos is where we're getting that information. Look at all of these exhibits, though, that he's citing. That's fantastic. That's a lot of evidence put in for the judge. In a photo taken by Carpinteria, I'm going to say that name wrong every time, everybody, every time. Vice Mayor Monica Solorzano, hopefully that's close. Troops stand several feet behind a federal law enforcement officer whose clothing does not indicate which agency he's affiliated with, which is a big deal. In a photo published by the Department of Defense, a Task Force 51 member is standing on a military vehicle on Casitas Pass Road. So they're taking the pictures and showing, one, they're not in compliance with the dress code, and two, that they're sitting on this particular area. And as shown in a video taken by Ms. Solorzano, Task Force 51 troops physically turned away a woman with a megaphone as she approached the traffic blockade. Camarillo, is that right? I'm going to say it wrong. I apologize. My goodness. Also, on July 10th, approximately 80 Task Force 51 troops were deployed to a cannabis farm in Camarillo, California, approximately 50 miles from downtown Los Angeles. Though there was initially a request for assistance from Task Force 51 in Camarillo, the lead agency canceled the request 2 days before the operation. So they asked, but then they said, we don't need anything. Once federal law enforcement began the operation in Camarillo, however, they determined that they needed assistance from Task Force 51 to respond to crowds that had gathered on the road near the facility and that were throwing rocks and damaging federal vehicles, including with a makeshift spike strip. Federal law enforcement agents were also overwhelmed by the number of undocumented immigrants at the cannabis farm. And then we have footnote 5 here. So they're overwhelmed by the numbers. We got a quantity issue. That's interesting. Number 5 down here. In fact, a farm worker, Jamie Alanis, unalived after falling off the roof of a greenhouse during the operation. Oh my gosh, I hadn't heard about that. Did you all hear about that? Oh my gosh. Camarillo. Okay, oh my gosh, thank you so much. Camarillo. I'm going to put it down here because I'm going to get it wrong each time. The problem is that there's two, well, there's no problem. The problem is me, clearly. But that there's 2 L's, and that makes me want to do a Y sound. So, yes, I hadn't known. Oh, he freaked out. Oh, that's so sad. Oh my gosh, that's really awful. Chased him right off the roof. Oh my goodness. That's terrible. That's terrible. So sad. Yeah, it really is. Oh, Camarillo. Okay. Camarillo. All right, everybody. All right. Wish me luck. I will try my best. But moment for this person who fell off of the roof. That's so sad. So sad. Let me just make sure here I'm in the right place. All right, deployed, assisted to prevent individuals and victims from vehicles from traveling on the roads near the law enforcement operation. Here we go. We've got some more. So, subsection E, the future of the National Guard in California. As of August 11th, 300 federalized California National Guard members remain part of Task Force 51. Those 300 troops are responding to 4 requests for assistance, 2 requests for protection of federal property, and 2 requests for protection of federal personnel and functions. Secretary Hegseth extended the deployment of these troops in Los Angeles by 90 days. Los Angeles was the first U.S. city where President T. Rump and Secretary Hegseth deployed troops, but not the last. Following criticisms by President Trump of the crime rate in Washington, D.C., Hegseth announced that the National Guard troops would be deployed there to stand with law enforcement partners, which he said was the same thing the National Guard did in Los Angeles. And we're going to pause this for a minute. And, you know, everyone, I think it's worth noting that I have no doubt all of this stuff is part of a plan, of course. And once he came into office, they were just waiting for the moment to be like, okay, that's it. LA, everyone, let's do it. Or DC, let's do it. So they were waiting until those moments presented themselves where people thought this would be a great opportunity. So I've got no doubt that they still have a plan for other places and so on. But according to the courts, we're going to have to see how this breaks down. All right, so National Guard did in Los Angeles. And then 6 here, defendants objected to the relevance of Secretary Hegseth's August 11th statements. These statements go directly to the propriety of injunctive relief. President Trump has since raised similar criticisms about Oakland, Baltimore, Chicago, and San Francisco, insinuating that he intends to send the National Guard or military to those cities. Here's their citation, quote, "Look at what the Democrats have done to San Francisco." Trump told reporters, "They've destroyed it. We could clean that up too. We'll clean that one up too." Oh my goodness. It's awful. This is so awful. Right. And I feel bad for the troops too, for the National Guard, guardsmen and women. I feel bad for them too. All right, conclusions of law for this piece. The court begins with a discussion of the historical context in which the Posse Comitatus Act was passed. Then the court addresses 2 of the defendants' threshold arguments. Their challenge to plaintiff's standing, meaning their ability to actually bring the lawsuit, and their contention that the Posse Comitatus Act does not apply to National Guard troops. All right, so first argument, no standing to bring the case. Second argument, doesn't apply to National Guard, federalized under 10 USC section 12406(3) before evaluating whether defendants violated the Posse Comitatus Act. Finally, the court considers the propriety of injunctive ultra-vires relief. Again, ultra-vires is a fancy way of saying they are exceeding their own authority. Before turning to the history and parties arguments, though some observations are in order. So the court's going to start setting out some definitions and pieces here to make sure everyone's using the same set of words. Loophole, governor activated, and that can be used. Oh, good Lord. Oh, Navy vet. Oh my gosh. All I can say is get under the stairs. So we say when the tornado's coming in, get under the stairs of the basement. Oh my gosh, Texas is, it's troublesome. All right, here we go. First, it is emphatically the province and duty of the judicial department to say what the law is. We're quoting, of course, Marbury versus Madison, which was decided in 1803. And I'm just trying to make sure. I'm not sure if Hamilton had been killed by this point. That's what I'm using. I'm using Hamilton's duel as a way to set the timeline here. I can't remember if it was 04 or before 04, but so I'm not sure. Anyway, Hamilton may or may not have been alive at the time. Without question, this principle applies to cases like this one, where the executive is accused of overstepping bounds set out by the legislature. If the president claims authority to act, but in fact exercises mere individual will and authority without law, the courts may say so. And we're citing a Trump case over here, although there are so many. I'm not sure which one this one is, but this is 2024. So that leads me to believe this is the presidential privilege case here, presidential immunity. All right, 603 U.S. That's going to drive me bonkers here if I can't find it. Hold on just a second. Just a second. All right, here's the immunity case. So let's just see. If this is the one. 603, yes. All right, yay, we were right, everybody. That is the immunity case. Oh, all right. So, okay, they're quoting out of the immunity case here, citation omitted. Especially where the foundation of our Constitution system is at issue. The judiciary has a responsibility to decide cases properly before it, even those it would gladly avoid. And we're citing multiple cases here. There's a Clinton case here, Cohen's v. Virginia. Ooh, 1821. Yes. Morrison v. Olson. That's another super old one here. So Scalia's dissenting, and they're quoting, discussing, quote, the allocation of power among Congress, the president, and the courts in such fashion as to preserve the equilibrium the Constitution sought to establish, so that a gradual concentration of the several powers in the same department can effectively be resisted. And he is quoting the Federalist number 51. Okay. All right, and then also note that the Federalist Papers were all written before the ratification of the Constitution. So second, though courts have not yet squarely faced the issue of a president using the military domestically in violation of federal law, the Supreme Court has clarified that the courts are not powerless to stop such executive overreach. After the assassination of Dr. Martin Luther King Jr., President Johnson ordered federal troops to assist local authorities with domestic surveillance pursuant to the Insurrection Act, because there was a huge issue, right? I mean, we had something that occurred, and then the president was like, wow, stars, we've got to protect the situation. Yeah, unlike here where it's like, well, I'm in office now. So, all right, a group of citizens concerned about the surveillance brought a class action seeking declaratory and injunctive relief. The court found that the plaintiffs had not alleged injury in fact and therefore lacked standing. All right, again, this is that concept that you've got to have the ability to actually even bring the case forward. So here, one of the 4 pieces of standing involves having an actual injury, and they did not. So, rejecting the plaintiff's argument under the First Amendment that the government surveillance chilled their speech. Though the court could have ended there, it did not. It went on to explain, and here's our quote here. Just to make sure we have this. This is from Laird and Tatum, so we don't forget which case this quote's from. Let me just put this over here, Tatum. And this is 1972. All right. We've got the concerns of the executive and legislative branches in response to disclosure of the Army surveillance activities, and indeed the claims alleged in the complaint reflect a traditional and strong resistance of Americans to any military intrusion into civilian affairs. That tradition has deep roots in our history and found early expression, for example, in the Third Amendment's explicit prohibition against quartering soldiers in private homes without consent, and in the constitutional provisions for civilian control of the military. Those prohibitions are not directly presented by this case, but their philosophical underpinnings explain our tradition, our traditional insistence on limitations on military operations in peacetime. Indeed, when presented with claims of judicially cognizable injury resulting from military intrusion into the civilian sector, federal courts are fully empowered to consider claims of those asserting such injury. There's nothing in our nation's history or in this court's decided cases, including our holding today, that can properly be seen as giving any indication that actual or threatened injury by reason of unlawful activities of the military would go unnoticed or unremedied. So that's a lot. It's a lot of language there. And side note again, the Second Circuit is the only circuit that has applied the Third Amendment through the incorporation doctrine. Just FYI. All right, sub A, history of the Posse Comitatus Act. All right, get ready. So everybody got their scotch and their cigars, right? Because we're all going to be sitting around like the old school fellas, like, let's discuss history, blah, 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 blah. At least that's what I imagine. Bourbon. Oh my goodness. Well, I've got Tang, all right? I've got Tang and mints. So we're going to dive in with that. That's how things go these days. Subsection A, history of Posse Comitatus. Oh my gosh. In 1878, Hamilton was dead. Congress passed the Posse Comitatus Act, which, as amended, states that whoever, except in cases and under circumstances expressly authorized by the Constitution or Act of Congress, willfully uses any part of the Army, the Navy, the Marine Corps, the Air Force, or Space Force, that was added later, as a Posse Comitatus, or otherwise to execute the law, shall be fined under this title or imprisoned not more than 2 years or both. So that's it. This is it for the statute. That's all there is to it. And the way the statute's written is they're not saying, well, don't do this. What they're saying is, boom, if you do this, you are going to be charged. So it's a little bit backwards off of that. Right. So in 1878, we have to remember we are through the Civil War. And so we're into kind of this middle area where we're trying to put everything back together again. So Reconstruction, T straight. What? Oh, Pedialyte, yes, winning for that. To fully grasp the Posse Comitatus Act and its role in our constitutional system of government requires a historical perspective. Thank you, Scalia. Number 1, founding era. The presence and role of British troops in the colonies gave rise to some of the first American criticisms of domestic use of military troops in peacetime. So this is kind of a special thing to do with the U.S. because the king had so many troops over here. Oh, woo, thanks, John. Powerball ticket. Yes. Oh my goodness. I don't know. I swear the last time I got one, I got so wrapped up in, for some reason, I'm like, oh my gosh, this could be it. I could have won it. And so I was sitting there listening to the numbers and for some reason, and I'm like, I just lost 2 hours of my life and I'll never get it back because my numbers weren't right. But I really thought it would be good. I was like this close to buying a house for my mom. Oh, all right. Sorry, squirrel. Ah, the founding era, the presence and role of British troops in the colonies gave rise to some of the first criticisms. And for instance, that's funny, a flashback, the trauma flashback to the time I bought the Powerball ticket. Don't get me started on the scratch tickets because I'm not allowed to use those anymore. Oh my gosh. All right. British troops were stationed in Boston as a force of uniformed peacekeepers or policemen. And then we've got citations here. Public resentment of the use of the troops in such a manner sparked the Boston Massacre. So, as we know about the Boston Massacre, everyone, that had to do with just a handful of soldiers decked out in full military regalia and then a group of other people. All right, so there's a lot of controversy behind that, which led in turn to the further heightened resentment. Indeed, resentment of Britain's use of military troops as a police force was manifested in the Declaration of Independence, where one of the American colonists' grievances was that the king had affected to render the military independent of and superior to the civil power. That's so important because they're saying we have two separate types of power, military and civilian. So that was set out as well. The Declaration of Independence, and we're going to be looking here, look at that, 1776. I love when they cite the Declaration of Independence. And then we have footnote 7. I have slowly been going through all 27 grievances over on the TikTok if you're interested. I think we're up to 10. Other grievances related to Britain's use of troops in the colonies were that the king had kept among us in times of peace standing armies without the consent of our legislatures and quartered large bodies of armed troops among us. And that was a really big problem because, you know, they were not all honorable soldiers either. So that was a problem. It was a big problem. Concerns about the domestic role of the military persisted into the drafting and ratification of the Constitution, where they came into tension with pragmatic realities surrounding the founding of a new nation. On the one hand, many of the founders recognized the dangers imposed by a centralized military force, and some advocated for significant, if not total, reliance on militias rather than federal troops. Here, citation. This one's 1836, quoting Edmund Randolph at the Virginia Ratification Convention. With respect to a standing army, I believe there was not a member in the Federal Convention who did not feel indignation at such an institution. So they were pretty upset about military crossing over into their lives. That's why, again, that peace the Third Amendment is so high up in the amendments, right? So the First Amendment sets out those fundamental pieces. Second Amendment sets out the right to bear arms and the militia piece of that. And then the very next amendment has to do with soldiers being quartered in homes. So that was so important. It made it into the top 3. It got like the bronze medal because it was such a huge issue at the time. On the other hand, some founders recognized that a standing army would be necessary to the security of a young United States. And then we've got the Federalist number 24 by Hamilton, arguing in favor of a standing army as a security force against Britain, Spain, and indigenous nations. And then we have Federalist number 41, Madison, a standing force, therefore, is dangerous at the same time that it may be a necessary provision. And that was according to Madison. Does anybody know that James Madison was 5'4"? I just thought I would throw that out there. I mean, I'm just saying, Napoleon was what, 5'7"? And then Madison was 5'4", just a teeny tiny little man. Here he is. here's Madison. You know, you can't tell based off of scale here, but he was a wee short little man and just did amazing work. Was, of course, incredibly important to the founding of the country. All right, so for all you shorties out there, just remember that, you know, short people can do amazing stuff. Just not if it's on the top shelf, all right? Oh, all right, the structure of the Constitution reflects these debates. The Constitution granted to the federal government significant authority over the military, but it split that authority between the executive and the legislature. The Constitution provided that the president shall be the commander-in-chief of the Army and Navy of the United States and of the militia of the several states when called into the actual service of the United States. So this is the language stating that National Guard is at the state level unless it gets pulled into a federal question. Oh my gosh, we really do. We really do make excellent climbers. That's a good point. Oh my gosh, that's a really important point. But the Constitution gave to Congress, not the president, the bulk of the federal authority over the military. Has anyone noticed that? I feel like no one's really paid attention to that because he's like, I'm the commander-in-chief, blah, blah, blah. But then when you look and you see how the military works, it's like all under the duties of Congress, including the power to declare war. And we're under Article 1, Section 8, Clause 11, to raise and support armies. Article 1, Section 8, Clause 12, to provide for the calling forth of the militia to execute the laws of the Union, suppress insurrections, and repel invasions. Article 1, Section 8, Clause 15, and to provide for ongoing arming and disciplining the militia and for governing such part of them as may be employed in the service of the United States. Article 1, Section 8, Clause 16. Alexander Hamilton explained, quote, the whole power of raising armies was lodged in the legislature, not in the executive, and this legislature was to be a popular body consisting of representatives of the people, periodically elected. So keep in mind too, though, when both Madison and Hamilton are making these claims in the Federalist Papers, that the senators would be chosen by the state legislatures. I think that's an important note, all right? So we get 2 senators and they're pulled in by popular vote, and then we have our House of Representatives, popular vote. In the beginning, the original situation had it so that the senators were chosen by the leadership in the state's legislature, all right? So keep that in mind. They only had 1 popular vote here. I think that's important. Can be 7 feet when needed. Heck yeah. Oh my gosh. One of the funniest things that I remember when I was teaching is when I was in a classroom teaching and I'd have like 50 students. They come to the front after I was done and they would talk to me. And I swear to you, every single time it was the end of class, somebody would be like, I thought you were taller. And I'm like, nope, it's just my hair. Oh my gosh. Yeah, that's all right. We can be short. There's nothing wrong with that. Focusing in on the malicious clauses language, permitting Congress to provide for calling forth the militia to execute the laws of the Union. Language that evokes the principles at issue in the Posse Comitatus Act reveals uncertainty in the nation's early years regarding whether and how the federal military, including the federalized militia, could engage in federal law enforcement. To start, this language was a subject of some debate during the ratification process for the Constitution. Patrick Henry, which, by the way, it should be noted, was one of the primary writers of the Anti-Federalist Papers. All right, so we do have all of these Federalist Papers, right, from Hamilton, Madison, and John Jay. Poor John Jay, he does not get enough credit. That guy was amazing. Anyway, so the Anti-Federalist Papers came out as well, and those were written primarily by Patrick Henry. So Patrick Henry, for example, worried that Congress would regularly use this provision to enforce federal laws. George Nicholas, a member of the Virginia House of Delegates, responded that Congress's power to call forth the militia to execute the laws would be exercised only if found absolutely necessary. James Madison explained that the use of the militia for this purpose would never be put into practice, where civil authorities were able to execute the laws on their own. So again, Madison is coming in here, as most the scholars have read when reading through this act and how it's supposed to be implemented. He's saying only can military be involved if local law enforcement cannot keep the rule of law. And that's, that's a really important piece, right? That's the only time that could even come in as a question. Hamilton, too, specifically rejected the idea that the militia clause would permit the militia to serve as a Posse Comitatus, that means local law enforcement, to enforce domestic laws unless necessary. In response to criticism that the Constitution provided no authority for the federal government to call out a Posse Comitatus to enforce the laws, Hamilton explained that Congress's right, quote, to pass all laws necessary and proper to execute its declared powers, end quote, would necessarily, quote, include that of requiring the assistance of citizens to the officers who may be entrusted with the execution of those laws. And then that's an end quote right there. And that would be Federalist number 29. He went on to explain why that the militia could not serve as a Posse Comitatus, it being therefore evident that the supposition of a want of power to require the aid of the Posse Comitatus is entirely destitute of color. It will follow that the conclusion which has been drawn from it in its application to the federal government over the militia is as uncandid as it is illogical. Yeah, Hamilton's writing's not the easiest to read. It's a little extra wordy in my humble opinion. It certainly does not seem like he's writing like he's running out of time, because he just goes on and on about the stuff. It's like he needs to think that he was running out of time, so he was like, stop it, but he didn't. Sorry, squirrel. The founders thus coalesced around a narrow interpretation of the militia clause, one which granted power to Congress, not the president. Number 2, the Reconstruction era, which, we, after any war that we have a process of Reconstruction. So the War of 1812, the Spanish-American War, the Mexican-American War. After all of these came this period again of Reconstruction. Almost exactly 100 years after the original 13 states ratified the Constitution, Congress passed the Posse Comitatus Act. The historical context of Reconstruction is as important to interpreting the act as the constitutional framework described above. Again, that's one of the things. No matter what you do, if there's a piece of law that was passed after the Civil War, within like the first 20 years after the Civil War, it's going to be seen through a lens of the Civil War. Like, that wasn't just put to bed. That was something that was every single day in the minds of elected officials. In the aftermath of the Civil War, federal troops remained stationed in the southern states and continued to enforce federal law. And then we've got a citation here. This included federal voting law and the Reconstruction Amendments, which are the 13th, 14th, and 15th. All right, those are the Reconstruction Amendments. In the 1876 presidential election, federal troops were stationed near polling places in Florida, South Carolina, and Louisiana to ensure that newly enfranchised former slaves could vote. Man, that's a tough time. That's a really tough time in history here. Then President Grant had a special message to the House of Representatives in 1877. Here, when the election results came in with President Hayes, a Republican from Ohio, winning by a slim margin and in dubious circumstances following disputed wins in the 3 states where federal troops were stationed, Southern Democrats promptly sought to remove federal troops from their states. So let's pause here for a quick side road again, everyone. one of the things that I think is the most, in my opinion, my humble opinion, side note here, that's one of the most harmful things that's come out of the situation with Trump has been this idea that our elections were just fine before. There were no problems. Nobody called anybody out on anything until Trump came in with his, BS story in the 2020 election, right? I'm sorry, yeah, that's right, isn't it? It was 2020. Yeah, that's right. Anyway, you know what I'm saying, right? So the problem was, of course, right, the election was stolen or all of this other stuff and all the lawsuits and such. But if you look past, into the history, we've always had dumbasses come up and be like, your election was fraudulent. So a lot of times the media portrayed it like for the first time in our history, thank you, 2020, for the first time in America's history, they're questioning the voting process. And I was like, all right, I mean, if that's going to sell your newspaper article, but in all honesty, we had issues with voting all the way back to 1800. I think truly the only time we ever had a completely open, honest, non-tarnished voting situation was prior to 1800. And historically, it backs it up. So we've got all kinds of situations where things have been going, wonky. But I think people forget about it. So when people are like, well, this is the first time democracy is being challenged, that's just not true. It's just not historically correct. As Mega was 2016, Russia in 2020. So he was Russian? No, I'm kidding you, Navy vet. I gotcha. I gotcha. I'm not good with numbers, but y'all know what I mean, right? How it's not one single guy with like weird hair coming down an escalator that is completely destroying our voting process. We've had a lot of people try to come in and mess with the voting process before, and we've taken care of it before, so we'll take care of it again. That's how I try to look at it. All right, so spreading the positivity around. Here we go. So the Southern Democrats were upset. Then they wanted the federal troops out because they're saying the federal troops were responsible for the winning votes, essentially, for President Hayes. Setting it up in case he lost. Right. Well, yeah. And, again, though, there have been a lot of different ways over the years in American history where some people have gone in and kind of, messed with stuff. And I was there too. I was there as well. I was like, oh my gosh, this is the first time we've had somebody this shady, like the Hamburglar, coming in and taking our voting machines. But then, doing some research and pulling back from the presidential elections that had come before, it's like, no, this just happens sometimes. Yeah, that's a lot. Oh, all right. In May of 1878, Representative William Kimmel of Maryland, I wonder if he's Johnny Kimball, or is it John Kimball? Is that right? Oh my gosh, I forgot his name. Dave Kimmel? I don't know. You know what I'm saying though, right? That funny guy of Maryland introduced the Posse Comitatus Act in the House of Representatives. Good for him. We needed that. 1878, he began his support for the act by stating, it's Jimmy, thank you so much, I appreciate that, by stating, I have the deepest conviction that upon a proper adjustment of it depends the peace, and I fear the liberties of the people. I confess that the more deeply I inquire into a steady growth of the standing army and the uses to which it has been applied, the stronger my conviction becomes that the highest patriotism demands the wisest precautionary measures. To that I say, that's right. Thank you, sir. That's a pretty heavy quote here. Kimmel went on to discuss English, Roman, and early U.S. history, citing various founders in support of his position. He then turned to the concern that deploying the military domestically to execute the laws would enlarge the power of the executive. So that's here. Jimmy, all right. Jimmy, I just hope I don't forget it, everybody. For some reason, I'm just terrible with names. I'm just terrible. Like, I remember I met a cousin in Colorado, and they're like, this is cousin so-and-so. And still, I'm just like, what's their name? Anyway, governors, sheriffs, and other states and local officers and United States district attorneys. This is really a key piece, everyone. Let me start back up again. This is really important right now. Governors, sheriffs, and other state and local officers and United States district attorneys, assistant marshals, collectors of revenue, and other revenue officers requested these generals, and these generals, at the request at these officers, precipitated these troops upon the people. If this may be done in one district, may it not be done in all districts? If so, and the interest of a president demands, may he not use this power for his own purpose? Look, right there, everybody, right there. They're saying the president can have the intent to use it for his own reasons. May he not by this means subject every reluctant commander to the order of any political miscreant. He may choose to make an assistant collector of revenue until the whole army is under his control, and then provoke the resistance he seeks for the employment of force, and in the name of order, substitute his will for law. I mean, this is just huge. He's saying you don't want him, the president, to come in and start commanding things because that's what he wants. He's supposed to do it in compliance with the Constitution, right? So that's pretty important. To be sure, Kimmel's high-minded principles were not Southern Democrats only, or even their primary motivation for passing the Posse Comitatus Act. The act was in many ways a referendum on whether Black Americans would be able to vote in Southern states. And then we've got a citation here. But whatever political motivations laid behind Congress's vote on the Posse Comitatus Act, the fact remains that the act was a response to systemic federal military involvement in domestic law enforcement. And then next up, we've got standing. Again, this is incredibly important in every single one of the cases here. I know I've said it a million times and I'll say it a million more, but that's the key. With the background of Posse Comitatus Act in mind, the court now turns to the question of plaintiffs standing to sue. Here, Article 3 of the Constitution requires that a plaintiff have suffered an injury in fact, concrete and imminent harm to a legally protected interest, like property or money, that is fairly traceable to the challenged conduct and likely to be redressed by the lawsuit. So those are the 4 factors that we set out when we're talking about negligence, right? So duty, breach of duty, causation, and then damages. So it's very similar. You need to have an act here involved a concrete injury and a protected interest, and then that causation piece as well, to put one back with the other. And they're citing the Biden v. Nebraska case, that's the student loans case, and then they're citing the Lujan v. Defenders of Wildlife, which this really is the standing case for suing the federal government. If anyone wants to know, this is the one. It's the Lujan case. Moreover, an injury in fact must be legally and judicially cognizable. All right. The parties focus on whether California, rather than Governor Newsom, has standing to pursue this action against defendants. That is sufficient for Article 3 purposes. Defendants challenge 1, whether an injury exists, and 2, whether any such injury is cognizable. And then we've got the docket citation here. Plaintiffs identify 3 potential injuries overall. Number 1, an injury to California's role in the federal system. 2, a fiscal injury to the state economy. And 3, an injury to the health and well-being of California citizens. The court considers these 3 proposed injuries to determine whether they are cognizable or redressable injuries. All right, so first one, federal-state relations. And again, this is really what the fight is about in court, like every single day. States have an interest in securing observance of the terms under which they participate in the federal system. That's really important, right? So they've got an interest in how the federal system affects their state and what happens in their state. So states have standing when they believe that the federal government has intruded upon areas traditionally within states' control. We've got a couple cases cited here. And you're going to see this kind of an analysis done on all of the voting changes that they're trying to do, right? So Louisiana's got some voting changes going on. I think Texas, this idea of like no more mail-in voting, that kind of stuff. Like all of this is under the purview of the state's power according to the Constitution. So, that's important. So, two cases cited here: states may have standing based on federal assertion of authority to regulate matters they believe they control. And 23, in this case, plaintiffs allege that defendants have violated the Posse Comitatus Act and, in doing so, infringed on California's police power. The police power is the quintessential power that the Constitution reserves to the states. That's really important to remember here. And then we've got the Morrison case observing that the reservation of police power to the states is one of the few principles that has been consistent since the Constitution was adopted. And this is the Gibbons v. Ogden case out of 1824. This is one of our landmark cases here. No direct general power over these objects is granted to Congress, and consequently they remain subject to state legislation. Because defendants' alleged violations of the Posse Comitatus Act include allegations that Task Force 51 troops have engaged in law enforcement, a domain traditionally within the state's control, California has suffered an injury that gives it standing to challenge those violations. So you see what they did here? They said the state of California has standing because of how it's being applied to the states, right? So they're coming in with federal power, and that will negatively affect their state, and so that means they've got enough of an injury to bring a lawsuit. Let's jump down here to footnote 8. The court earlier explained why defendants use 10 U.S. Code Section 12406 to federalize the California National Guard likely violated the 10th Amendment. Ooh, that's another good one right there. So we have one court now coming in, setting precedents. This is a big moment here, where they are saying, we don't think you can actually use this section of law to justify federalizing the National Guard. They're not saying you can't federalize it, but what the judge is saying is you can't necessarily use this piece of the law in order to federalize California's National Guard because of the violations of the 10th Amendment. And that's huge. That's that state versus federal piece in here. So very important to note that. What injury did they incur? Wouldn't it need some sort of monetary value? Great question, and no. Monetary value is one of any kind of damage that can be done. It doesn't have to involve money. It can involve just power or reputation or diligence. There can be a lot of other pieces at play. You don't actually have to have a money injury, although that is the easiest one to do. For sure. Quintessential power, yes. Yes, indeed. Oh my gosh. Restitution, yes, yes. But again, you can see if I just back up a little bit to the last sentence here, because defendants' alleged violations of the Posse Comitatus Act include allegations Task Force 51 troops have engaged in law enforcement, all right, so that's the act that hurt them, a domain traditionally within the state's control. So here, the harm done was a loss of the state's control. California has suffered an injury that gives it standing to challenge those violations. So, to flip the language around, with federal law enforcement enforcing local California law, that's taking control or sovereignty away from the state. And that level of harm rises to the level of being able to have standing for the state. Maybe that's a little bit better way to talk about that one. All right. Next is the question whether California's injury is legally and judicially cognizable. That is, whether the dispute is traditionally thought to be capable of resolution through judicial process. So this is another piece a lot of people forget about. You've got to have some kind of a remedy that the court can give you in order to bring your lawsuit. Because if the court can't do anything, they can't do anything. So that's another important piece as well. I don't see how California was injured from sitting some troops at a building. They didn't even arrest people. They just stood around. Sure. Well, and that's the thing is like they didn't have to do anything. They just had to be there because by being there, and then those of them that did go forward and practice engaged in law enforcement took the sovereignty away from California. So, I mean, that's what they did. They're like, hey, we're just going to stand here on federal property, fine. But some of them didn't just stand there. Some of them did participate in law enforcement. Even if they're standing in front of a federal building, if they're doing some kind of crowd control, that would be state law. So for them to be enforcing state law pulls power away from California. So that's the key here. A security guard at a building, then the cops post up in yeah, I'm not sure. I'm trying to help you here, Rami, but the whole bit here is federal government and state governments, two different roads. You can't come in as the federal government or as the president and just be like, well, California's mine now. I'm taking it from the governor. Like, you can't do that. And that's the same thing here. Like, well, National Guard is under my control now, so we're going to enforce California law, whether you like it or not. Like, that's not okay. Like, that's like Civil War level issues with sovereignty. All right. All right. Next is the question whether California's injury is legally or justiciably cognizable. That is, whether the dispute's traditionally thought to be capable of resolution through judicial process. Defendants argue there's no historical example of a litigant obtaining a prospective injunction requiring federal government compliance with the federal criminal statute with a willfulness requirement that the executive branch is charged with enforcing. So they're trying to get around this idea that they're engaged in law enforcement for California state law. So they're going to try to flip it around and say, no, we were only enforcing federal law because they know they're not allowed to be enforcing state law. To the extent that this is a question of standing as opposed to a merits question about whether injunctive relief is appropriate or available here, it specifically implicates redressability, which is that final piece of being able to bring a lawsuit. Now let's bump back here and let's go back here to the footnote 9 here. Oh, the nails. Oh, thank you so much. Yeah, I've got my bright nails on tonight. I was like, I couldn't quite see the word nails. I was like, my what? I appreciate that. Okay, here we go. Footnote 9. Defendants get out over their skis. Ooh, I love that when judges say that. The defendants get out over their skis in proposing that the court parse the question more finely at the standing stage and ask now whether in a one-of-a-kind scenario a specific remedy can be had against a specific party. That issue is better addressed after a thorough analysis of the plaintiff's claims when determining what remedy, if any, is appropriate. The point in its order. This approach is perfectly consistent with U.S. v. Texas, where the court found that a wholly novel form of relief was fundamentally at odds with well-established doctrines of prosecutorial and enforcement discretion and was not redressable as a matter of law. So that's our footnote number 9 here. Well said, Judge Sue. And we had just flipped, so here we go. I remember I put an arrow to remind me we had just flipped. Where you find that, you're saying National Guard was assisting ICE in midnight raids. Yeah, I mean, that's the thing, right? When you get a whole bunch of people in uniform standing around and then there's an issue with the coppers arresting somebody, you think they're just going to stand there and watch it? No. So they're going to go in there and they're going to try to assist. And the problem is when you assist, you are assisting local law enforcement enforce local law, and that's not within your jurisdiction. It's just that simple. It's just that simple. Right. Right. It's just that simple, right? States don't have a lot of rights, but the rights they do have, they're very careful about protecting. And one of them is the law enforcement for their rules. And you can't come in and pull rank as a federal officer and say, well, we're going to enforce the law here. It's like, that's not your spot. That's not your place. All right, so Texas here asking whether the asserted injury is traditionally redressable in federal court. No one disputes that injunctive relief is available against federal government and its agencies, right? And an injunction preventing Task Force 51 troops from engaging in law enforcement activities traditionally reserved to the states is likely to redress some of the harms discussed above. Thus, for purposes establishing standing, plaintiffs have suffered a cognizable injury. All right. So an injury has been established. The defendant said there was no injury, and the court is saying there was, and that's how we can go through it. Right. Well, I mean, originally too, Murray, the governors are the ones that ask for the assistance, right? They're the ones that make the call for the National Guard, except for in DC. The only person that can call that National Guard in DC is the president. That's just how it's written. Nobody else has the authority to call in the National Guard in DC, all right? But the governors in all of our states can come in and request help, with a few exceptions, one being, of course, Little Rock, Arkansas, where we were desegregating schools, and the governor of the state himself said we will not comply with the U.S. Supreme Court. So then we did have some military coming in to assist with that situation. All right, state economy, number 2, states have quasi-sovereign interest in the health and well-being, both physical and economic, of their residents in general. All right, recognizing economic harm as an injury in fact. Plaintiffs assert the state and its residents have suffered various forms of fiscal harm due to defendants' alleged Posse Comitatus Act violations. So they're coming in and they're like, look, we already have an injury, but here's another one if you've got a problem with the other ones. As to the state's financial losses, plaintiffs explain that the presence of the National Guard in Los Angeles has led to increased state law enforcement expenses. The problem with this argument is that California's alleged fiscal injury is not traceable to a Posse Comitatus Act violation, but to the National Guard's presence in Los Angeles in general. For instance, plaintiffs state that their largest expenditures in response to federal officers and troops' presence in Los Angeles came June 9th, 10th, and 11th. But their first specific example of a Posse Comitatus Act violation occurred on June 12th, when Marines briefly detained a veteran at the Wilshire Federal Building because plaintiffs do not connect their increased expenditures to any Posse Comitatus Act violations. Their fiscal harms do not give them standing. So they did come out and say, let's talk about money, and then the judge is like, nope, that one's not going to work. You're not going to be able to use that one. Oh my goodness. All right, the same is true of the asserted economic harms to California residents. ICE and Task Force 51's activity in Los Angeles has certainly sent economic shockwaves through Southern California. Citation, here. And let's not, talk about, well, let us not forget that poor Johnny's having to fly all over the place. We're over in Los Angeles, we're back in DC, now we're back in Los Angeles. So, just to give you an example. Poor guy. All right. But it is not apparent on this factual record which of these economic harms are traceable to alleged Posse Comitatus Act violations, or even the presence of Task Force 51 troops. It instead appears as though ICE operations generally have caused most of the economic impact to California residents. Once again, the alleged economic harm is not traceable to the conduct being complained of, so it's not sufficient for standing purposes. So what you have here again is the court saying, nice try, but no dice, because it's not going to work. So here they're saying the injury to the people of the state of California, and they're saying that's not enough here. And then the state itself, that's also not enough. So they're not winning on the money pieces. All right, let's just double check here. La, 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 la. See where we're going. All right, I'm gonna go ahead and pull to a stop here because this section's really big, really large. So with that, everyone, I will go ahead and mark us here so we remember where to pick up. So we're gonna need another live. We're gonna need another live to make it through this huge ass case. Oh my gosh. So what are we thinking, chat? How are we feeling about this? Is this kind of starting to make some sense? The Posse Comitatus rode the sovereignty issue between the state and the federal system. You are welcome, John. You are absolutely welcome. So yeah, I'm just wondering how we feel about it. You're welcome, Murray. Of course. Going through one, of course. Sounds solid. Yeah, I would agree with that. And also, too, it sounds like they're writing to the Supreme Court, which technically they're not, but, you know, once it hits the last of the appellate situation roads, it is going to be up to the Supreme Court. There's no doubt in my mind that the Supreme Court will want to make a ruling on whether or not federal executive can come in and take over with their National Guard. I think they're really going to be asking that question. It's really helpful. Oh, good. Yeah, California's got some good stuff. I mean, their taxes are a lot, right? I'm not gonna lie about that. It's really expensive out there, but they do good work overall. Upgrade, hello, thank you. Thanks for doing this. Oh, of course. I'm glad to see it. It has to be done. It certainly does. Makes sense, but there are lots of weeds during these. Oh my gosh, that's so true. That is just the truest statement ever. Weeds everywhere. Actually love it. Oh, good. As they're leaving it open, right, because they don't, well, right. So that's a good point too. A lot of our cases that we've been getting answers from by the U.S. Supreme Court are just kicking the can down the road. And by doing that, it's like they're like using a mulligan, or they're saying, we're not going to deal with this right now because we know you hate us. So we'll deal with this in 6 months when it goes through other courts so you can hate the other courts. The problem is that we don't hate the other courts because they're like doing their job. So there's that. California twice, really? Oh, yeah. And there's a lot going on. Yeah, there's just a lot. There's a lot going on. Yes, indeed. West Coast is like a different country. Oh, absolutely. Well, I mean, in my humble opinion, I feel like all of the states that border something, maybe because I'm stuck in the middle, but I think all of the states around the outside have a little different culture out there. Oh my gosh. Oh, that's so funny. They won't want SCOTUS to take it up. Well, right. Oh my gosh. Yeah, so there's a lot of that going on. I'm not sure what's going to happen with SCOTUS right now. SCOTUS is a mess, an absolute mess. I looked to Sotomayor, and Sotomayor's like, it's a damn mess. And so I'm like, oh dear. Oh dear, but we'll, keep trying. We'll keep going. There's lots of ways around things. And that's one thing too that, I would remind everybody of is when these laws or when these cases come down and they're saying some of this crazy stuff and you're like, what the H is that? You have to remember, as lawyers or as students of law, our job is to find a way around it. Find a legal way to get what you want, and then you will find it. So that's what a lot of our time is spent on right now, is trying to figure out like, okay, well, that's not right, but we don't want to deal with it. So let's find the alternative road until we get it sorted. So, yeah, and it's one way for the courts then to set their cases up. Now, with that, my friends, I will need to come and do another live on this one, which I'm happy to do. I'm really enjoying our time over here on the tube. So I would say Tube Tuesday, Tubing It on Tuesday will probably be my next visit. And then if we don't finish it up, I'll probably bring it back on Thursdays. All right, so Tuesdays for sure, 7 Central. 7 p.m. Central, and then I will pick up the next part of this case, and then hopefully we'll get it read by the end of the week. All right, everybody. So have a wonderful night. Thank you all for coming by and hanging out. I appreciate you all so much. This will be under the tab for the live, so you can go and check that out there. So have a great night, everybody.